Thank you so much, ma'am, for the presentation. There are a few queries in the chat box. I will read them out for your clarification, ma'am. Question from Miss Sarika Gaokar. Uh, Madam, if we use similar trademark in India, which are existing in a foreign country in a similar industry, would it be actionable in India?
Yeah. So if we use a similar trademark in India that is existing in a foreign country, yeah, it insofar as the development, how the cases are coming is concerned, uh, the answer to that question can be a straight yes. Yes, it can be the if the plaintiff is in situated in a foreign land and you are using a trademark that is similar to that of his in India. Uh, the right from I think 1998, the Supreme Court case of N.R. Dongre versus Whirlpool, it has been made clear that a foreign um, trademark owner can move against a local trademark and also get away with it. You know, so yes, it can be it the plaintiff for the foreign plaintiff can move against you, and even if your trademark is registered, fine, the foreign trademark owner might get it expunged from the register. Yes, that is possible.
Next question is from Mr. Purushothaman. Madam, what are the steps that must be taken while registering non-conventional trademarks? For example, with regards to sound trademark, we could remember countries like US, Australia accepted the Nokia ringtone, but Hong Kong rejected it. How to overcome such difficulties?
Yeah, you see, the the basic thing that one needs to consider here is if you want to register your non-conventional, as it is non-conventional, so that itself is a hurdle that you need to cross with the registry, the concerned law of that land where you are wanting to register it or use it, right? So it's better to get a clear picture as to what the law of that country talks about insofar as non-conventional trademark is concerned. Like for instance, in India, we are very clear insofar as the black letter law is concerned. Actually, we the if we just focus on the black letter law and no case law, right? Um, we cannot, two of the fundamental requirements are that your mark would be considered as a trademark only when it is capable of distinguishing the goods, your goods and services with those of the competitors, right? One is that, and another is it should be capable of graphical representation, right? Now, it is only by a stretch of argument that we have, um, which happened in a number of cases before the court, when the law was stretched, the argument was stretched to, incorporate the sound trademarks as within the definition, within the existing definition of trademark. Actually, our law, insofar as the written code is concerned, does not say anywhere that a trademark does not allow it openly. Sounds can be registered as trademarks. But so, what is the law of that land and how the case law in that particular territory has developed? That is that is the first thing that you should get a grip on uh, if you want to overcome these difficulties, right? Because uh, say for instance, France, well, basically France is known for perfume. So obviously they have smell trademarks, right? But then it's very difficult in India to get to convince the registry on this fact.
And we have one more question from Mr. Satyendra. Madam, if different businesses producing different products can use similar trademark?
Yes, that is possible. Selling different products can use similar
Yes, ma'am.
say for instance, prestige pressure cookers and prestige exhaust fans. So there are such instances, possibilities definitely there that the two businesses are different, dealing with different products, but they have very similar trademarks. Now, difficulty arises if the prior user of the trademark, right, has a problem with it. You see, a trademark comes under the scrutiny of the court only when there is a certain litigation. Otherwise, not. Otherwise, if the two businesses or the business proprietors, they are happy with and they do not have any problem with their trademarks being similar, then it's a happy situation for both of them and they can operate simultaneously in the market. No issue.
How to identify if a picture is free to use and is usable or not for trademark registration?
Our picture, yes. So there is a different search that is available on the trademark registry that is concerning, that is helpful in this regard, that is devoted and dedicated only to device trademarks, that is picture trademarks. So it would be good if to begin with that search is done in order to ascertain if your trademark or your device is going to land up in litigation in the future, or it's something safe to use.
There is one question from Mr. Mohan Rao. Madam, if trademark is not registered, what are the remedies available to the owner of the trademark for infringement of trademark in India?
If the trademark is not registered, the expression infringement cannot be used in respect of that trademark. There are two types of trademarks that operate, at least in India. One is registered trademark and another is unregistered trademark. So that means registration of a trademark is an option. It is not mandatory. It is an option available to you. You may, if you do not want to get it registered, you can use it in the unregistered form, but you have to use it in relation to some goods or services in course of trade, that is supply the market supply the market with those goods and services, right? And if you have chosen that you would keep, if you have exercised this option that you will keep your trademark unregistered, then the expression infringement cannot be used in relation to that. Infringement action for infringement is a right that is available only to the proprietor of a registered trademark, not to unregistered trademark. But having said that, it's not that the proprietor of the unregistered trademark is totally at sea and is a helpless person. The law does offer one very basic right to him, and that is not statutory law. That is not the act as such, but common law. It is a common law remedy, and the name of the remedy is passing off remedy, right? So passing off is basically when you are saying, see, this person or the defendant is passing off his goods or services as if they are mine. Actually, they are not mine, but he is misrepresenting to the public by projecting as if they are mine. So if the defendant is indulging in that sort of an activity, you being the proprietor of the unregistered trademark can initiate an action for passing off against him. So that's the remedy available.
One more question from Miss Yashodhara Patnaik. Madam, these days olfactory or smell trademark is also on talks. Can you share your views on it and how a smell can be trademarked?
Yes, the best possible. It's a very good question. Very good question, because since we are, as I said in my presentation also, smell is also a variety of non-conventional trademark. And India as such is, yes, quickly opening up. The registry is opening up to this whole phenomenon of accepting non-conventional trademarks within its fold, within its fold in the sense of granting them registration. Now, how it is possible in India? Again, it is possible. One clear-cut way is to amend the law and make it possible. That is not going to happen in my assessment, or at least in the near future. I do not see any possibility of that happening. So, how else can smell trademarks be accommodated? They'll have to choose the same way, backdoor entry, the way sound trademarks has gained a backdoor entry and entered the registration environment. So how can this be done when given the fact that the two requirements remain the same for all types of trademarks? If you want to um, categorize them as trademarks, see, a mark can be a trademark only when it is distinctive and only when it is capable of graphical representation. When now smell trademarks clearly cannot, right? Clearly cannot fulfill the second requirement. They might be distinctive. It might be a very distinctive smell. The moment you open the bottle, you might be able to discern and distinguish it with the competitors. So the first requirement is easy to fulfill, but insofar as the second requirement is concerned, graphical representation is quite tricky. Now, again, if we stretch our argument and if we stretch the domain of existing black letter law, one way of doing it could be to describe that smell, right? You describe that smell, and that is how the other registries in other jurisdictions outside India have been doing it, basically. Those who have similar, law similar to that of India. So what they do, the idea is to describe it as vividly and as much in detail as possible as to what that smell is similar to or what that smell is like, right? That is the other roundabout way of going about it. Now, what way India is going to choose eventually, if at all, is for the future to tell.
Thank you so much, ma'am. With that, we have come to the conclusion of the Q&A, ma'am.
Thank you.